the correction of the 5:30 to 5 o'clock start time.
All those in favor say aye.
Who seconded?
Rachel.
Oh,
The minutes for June 3rd, 2021 have been approved. We have no old applications. We'll move to new applications, S 2021-13. Michael Murphy's applying for a variance to reduce the rear yard setback. Oh, I've got ahead. Charlie, would you like to swear in those in
yes,
present?
gosh, I'd love to do that. Everyone who plans to speak tonight, if you could stand, raise your right hand, please. Do you swear or affirm the statements you're about to make to be the truth to the best of your information and belief? Thank you.
Always getting my cart before the horse. Matt, please speak to us.
Thank you. This first application is S-2021-13. It's a project site at 128 Summer Ridge Road. The application is for a variance to reduce the rear yard setback from 50 feet to 24 feet. The property is zoned agricultural. It's our A1 zoning district. The site is about 15.9 acres in size. I guess as a little bit of background information, there was a previous Board of Adjustment application that was approved for this site back in 2019. The applicant came and received a variance to reduce the front yard setback to allow a house to be built closer, or to get the setback reduced so that a house could be built closer to the road than would typically be allowed. In this case, the applicant applied for a farmstead exemption to build a detached garage. On the application form, you can see where the applicant had indicated that the garage was going to be 50 feet from the property line. Somewhere along the line, the detached garage turned out to be 24 feet from the property line. This was brought to staff's attention, and a letter was sent to the applicant to let them know that they either needed to move the structure or apply for a variance. Should the board deny the variance, the structure would need to be brought into compliance with the regs. We looked at other properties along Summer Ridge Road. From what I could see, only 3 other properties on the road received setback variances. 2 of those were so that when homes were being constructed, they could allow for some existing tree lines in the backyards to be preserved. Otherwise, they would have had to move the homes back and remove some trees. Let's see. I don't think I indicated what the third one was for. Oh, the third one was the applicants. So when we look at KRS 100.243, it lays out for us the findings that are necessary for granting variances. It talks about looking at whether it'll impact the public health, safety, or welfare, whether it will alter the character of the general vicinity, whether it would cause a harm or nuisance, or whether it would be an unreasonable circumvention of the regulations. And then it goes on to describe some things that we should also consider when we think about those things. So when I looked at this particular application, I don't find that approval of the variance would adversely impact the public health, safety, or welfare. I don't think that it would significantly alter the character of the properties in the area. I mean, it is a fairly heavily treed area, not necessarily between the building and the closest adjoining property owner. But I mean, in general, most of the people who use Summer Ridge Road on a daily basis probably didn't know that there was a detached structure back there. The parts where I do, I guess, take a little bit of exception, I do see a case where, the adjoining property owner could view it as a nuisance depending on what type of uses or noise occur in that building that is now, 26 feet closer to their property than what the applicant had told building inspection that it was going to be. I believe that adjoining property owner is here, so I'll let them speak to that, whether that is a nuisance. If you note in the staff report, I don't really, other than just mentioning that I could see the possibility, I don't really go into that very much more. My biggest concern is that I view it as being approval of the variance as being an unreasonable circumvention of the zoning regulations. What I would not want to see happen in future is lots of people apply for farmstead exemptions and then come back later, once they've built the property somewhere where they did not tell the building inspector that it was going to be, and apply for variances, and just ask that we give them that relief, sort of after the fact, rather than bringing an application before they build any structures and have it, the application sort of stand on its own merits rather than sort of begging for the mercy of the Board of Adjustment, if that makes sense to you all. When I look at the site, if we had gotten this application before any construction began, I don't think that there really would be very many merits for granting it. It is a almost 16-acre lot. There's lots of buildable area on the site that is within the 50-foot setbacks. There's the house the site that they received approval for a house, that they, at least on our latest aerial imagery, the house isn't there, but they may have started construction. I'm not sure. But I don't think that a strict application of the zoning regulations would deprive them of any type of use, that is enjoyed by other property owners. There are lots of properties, both in this development and, throughout Scott County with terrain like this, where, people build things within, the acceptable areas all the time. So I guess, based on the information that I have here in the staff report and my analysis, I do recommend denial of this application with those findings, those 7 findings that are there in the staff report. I don't do so lightly. Obviously, we try to find, when somebody, has put that kind of investment into their property, our job isn't to, protect that or destroy that. Our job is to enforce the laws that, in this case, Scott County has passed as far as land use, and we're guided by state statute as far as, what those necessary findings are when we consider granting variances. Should you approve the application, I do have the 2 conditions there. Those are standard that we include with every application, just that they abide by, our local zoning and subdivision and development regulations, and that they abide by all other state, local, and federal laws.
Thank you. Do you all have any questions of Matt?
I have one quick question, Matt. You mentioned that there might be a potential nuisance of words act to the neighbors or whatever. Do you know of anything currently being used in that building that is causing like a noise issue or anything else?
If there is, then it hasn't been brought to my attention.
You're not aware of it at the moment?
Yeah.
Okay.
I'm sorry.
Go ahead.
Any concerns from surrounding neighbors? I guess there is.
Yeah, they're here, he said.
Yeah, the issue was brought to us by one of the neighboring property owners.
Matt, you said a letter went out to the applicant stating that they were out of compliance. When did the letter go out?
I don't know the exact date. It was several months ago.
Okay.
Yeah.
That's what I was trying to get, wondering also, is the timeline, because you say that he appeared before us in 2019 to get the variance for the front yard.
Yes. I think this structure was in place before 2019.
It shows a building permit of 2018.
Yes.
Right.
That's what I'm trying to get, is the timeline.
Gotcha.
And was the building inspector actually out there at another site and approved another specific site, and then it was moved, or was that just a general?
My understanding, when people apply for farmstead exemption, there is no site visit by the building inspector.
Okay, so they just go by what was written, which said 50 foot
Yeah.
from the line? Okay.
Thank you.
Thank you.
Any other questions?
Mhm.
The applicant,
Built it before the house.
Mr. Murray, yes,
But
could you
farm-
please come and explain to
farm
us
versions
in
has
your
to
words, sir?
Yeah, well, in my defense, I sent a plat to Planning and Zoning. I don't know if you've got that in front of you. It's 10338.
We've got it.
I don't want my garage 24 foot from the property line. That was never my intention. That plat that shows 4 5-acre lots that I purchased, and each one, when I bought the property, were clearly defined and surveyed before I bought the property. So if you look at 10338, the plat there, you'll see 4 tracks. My garage is on one of them on the left. I I don't know what number it is.
Would you come up here and show us on that?
Okay.
He's referring to this.
This one right here?
Okay.
Yeah,
This plat right there
Yeah.
is my property. This was for sale,
yeah.
listed for sale.
So see, the house is here, but you've got the building up here.
Well, my building is right in this
Okay, yeah,
corner
that's
right
it, when you go
there.
up that gravel.
I had 4 lots. My house is on this one. It's
Right
actually
there.
that one right there.
Yeah,
And then this lot is this easement goes through between this one and that
Mm-hmm.
one. This is a little knob right there. It's just a little hill.
And this is a gravel.
This is a gravel road
Okay,
right in
that's
that's what
between
she
me.
sent us a picture of, yeah.
This was all marked off. All this, the easement was marked, staked off, flagged. This whole property was surveyed. In my opinion, it was surveyed when I bought it. I knew exactly where the property lines were at that time. In my mind, I didn't just go out there and put a garage.
So you're saying these survey lines were not correct?
This line is different than what it was when I bought the property. This line, right,
So they've changed it since when you bought it?
this line has moved about 12 foot on this end and about 25 feet on that end. There's pictures,
Yeah, we see the picture.
this is this line right there. This is, I don't know which one this is. This is the new one, that's the old line, right there. This line is gone. There was never, it was staked right there. I measured my building 50 foot off that line and 50 foot off, I'm sorry, this line right there. That little point right there is the line in question.
Matt, do you know who marked that original? I mean, like, was a survey done differently and resurveyed to correct it,
This
or?
survey that my neighbor got was just a few months ago, or
And it did contradict the one that was marked when you bought it?
everything looked like to me lined up at that one line right there, and that is different now.
That's the problem.
That's the problem. I found this out about 3 months ago, and, they told me to go get a survey. I don't even know a surveyor.
Shirley, how does that work if you buy property that's already surveyed and then the survey changes?
That's not something that happens. In fact, I can't tell you another instance where that happens, so. I mean, what you do is you get a survey that, from someone you have confidence
When
in,
you
and
buy
that's
it,
where
I
you
thought it
go.
was surveyed. We surveyed our land when we bought it
Yeah.
ourselves and knew where it was.
I agree. Like I said, I don't want my garage 24 foot close to the property line, and all I wanted was just time to get a survey. I don't know a surveyor. They called me in March or April and give me 30 days to dispute this claim, and I just simply want some time to get a survey, and then I'll figure it out then. I
This
don't
could be
want
a
to go down in
survey.
those woods right now.
I think. Yeah,
If that's the actual line, if that line is correct right now, I will move my garage somewhat if I have to. I don't have a problem with moving it some. I mean, there's a little area there. I don't think I can take it back 25 feet, but I can go back some if that turns out to be the right line. I just want to before I tear my building down, I would like to make sure that's the correct line.
Would that be proper to get another survey done? Like if we have two opposing?
Well, actually, it was my understanding that you got a couple of postponements here to get surveys, so I thought you would have had that by now.
I don't. Like I said, I didn't even know a surveyor. I don't know that I can tell somebody to get in 2 months. I mean, I have a business. I can't just call a surveyor and tell him to go survey a property.
Well, it looks like Darren Croucher did the survey to begin with Thoroughbred. My question is, why didn't you go back to him and just ask him to come out and look at it?
I don't know Darren Croucher. I don't know who that is.
It's Thoroughbred Engineering, which is on the plat.
And he'd be liable to go back and at
Well,
least
yeah, I mean,
justify what he did,
If
right?
he did the main survey for the
Exactly.
properties, then that's obvious, but yes.
Well, I'm having an issue with Thoroughbred right now, so I couldn't really go to them. So
Matt, do you all have a list of other surveyors in your office?
I hired a
that
surveyor.
people would-
We hired I had my attorney get a survey. He drew a picture and I assume you got that, it was just a drawing, it wasn't nothing to rely on, it was just something to show that I'd hired one. He just hadn't got down there and done it yet. I don't know if he wants to go down there now or not. I don't know what's involved in getting a survey. That is thick as all get out. I don't even want to go down those woods right now. And if you can't even get in through there, it's just so thick and steep. And I just don't understand what the hurry is for me to do that right now.
Well, there would be
Is
a
there
need
a
for
reason why it's got to be done just like immediately? I asked them for like 6 months
That's long.
to get a survey. As soon as it clears out a little bit, and that's the problem, I guess.
Any other questions?
Not yet, not yet.
What else? I mean, there's more. I'm just trying to think. But I didn't intentionally build my garage 24 foot to the property line. It was marked there, and I marked off 50 foot from each corner there and built my garage.
Well, and you acknowledge that in your staff, you don't think there was anything willfully done.
No, I don't think there was a willful violation.
Yeah.
But you're saying regardless of that, we still circumvent the law. I mean, it is what it is if there's no other justification. But it seems to me the survey issue, I mean, you're given a prompt. If we don't wait 6 months, but a prompt timeline, we might want to address this, or?
I mean, I guess we do have a recent survey. This one that was included in your
Okay.
packet was done by a licensed surveyor
Okay.
and signed.
I don't disagree with that, sir. I don't know that it's right. All I know is it's different on that one line than what it was. So,
I have to rely on the
Yes.
information
I
on the
understand,
survey.
I understand.
I'm not a licensed surveyor.
I don't think you're going to find another surveyor to dispute that one. I really don't think they will, do you?
I don't know, would a surveyor even want to get involved
That's
in
what I'm saying, to
disputing
find one
that?
dispute another
hired a
one, I don't know if
surveyor.
he did.
I don't know that he wants to get involved in a 15-foot property line dispute right there. And I wouldn't ask somebody I don't know to do that. I want to get a survey on my whole property, and I will do that as soon as, I just don't want to have to do it right now. I'm trying to figure out why I have to do it right now rather than just waiting till it. When do people survey property? They don't typically survey it this time of year, I don't think, or they don't like to.
We get plats year round.
Yeah.
Well, then maybe I'm wrong there. Maybe they will go down in there and do that, but I don't want to.
Thank you. We'll probably we want to hear from the
I
other people.
Let's see, we should ask.
Good evening.
Hi.
I'm Rob Johnson, and I want to make it clear for purposes of tonight, I only represent Alan Handelman. He owns the property immediately adjacent to this particular situation. And before I get going, I was hoping I could go ahead and hand out some information here to you. Basically, it has some things, some pictures, and some other things. Is it okay if I approach to do that? Okay.
The judges asked us to apply.
This is kind of fast.
That's so funny.
Someone we've had?
New world.
Yeah, for sure.
There you go. Thank you, appreciate it. What I've just handed, it's like Paul Harvey says, now it's time for the rest of the story. And so, what I've just handed you, and you may already have this plat, quite frankly, I wasn't sure all that you all had, so I just want to make sure that you all had everything that we felt was important. But what I've just handed you, if you turn the clip to up here and take a look at it, that's actually the plat that was done by the surveyor in this case. Of course, you can see the seal there right at the bottom middle of the surveyor. And what he did was he platted out where the property lines were there, followed the property lines that everybody has the ability to do. And he put on here where the barn was. And if you look, you'll see that the barn is more in the 50-foot setback than it is off the property. Now, some people might look at that and say, well, this is out in the country. I would say this to begin with. That's why you move out in the country, because you want some space away from other people. And if everyone is gonna be allowed to go ahead and move forward and do things and build things where they want without taking consideration of what the surveys are and where their property lines are, then that's obviously a concern for all citizens, quite frankly. What I wanted to do, and first of all, is if you turn to that second page, the blue line there shows you the property that Mr. Murphy owns. So if you're looking where the writing is, where you can read it, all that property is the property that Mr. Murphy owns. And so what Mr. Murphy did was, he came here several years ago, filed basically filed a petition, said, I want to build this barn, told you all on that petition it was going to be 50 feet back. How do I know he told you all that? Because if you flip to the next document, basically it's 1, 2, 3, 4, 5, 6 pages in where you see the PVA map. He attached that to his petition, and if you see the real dark square there, right above that real dark square says 50. He was telling you all that he was going to put that barn 50 feet off the 50 feet off the boundary line there. So he affirmatively made a statement that I'm going to build this barn 50 feet off the setback. Now, I'm not sure exactly why he comes to you all and tells you all he didn't know exactly where the property line was. Because, as someone just pointed out, it's your responsibility, it's your responsibility to know where your property line is. And if you're going to build a building, it's your responsibility to make sure that that you decide, where it needs to be, so that when you build the building, it's done legally. Now, it wouldn't be so bad if the same person who's coming to you all, asking you all for a variance, wasn't actually opposing someone else's ability to use their property the way they feel like they want to use their property. But that's what's happening in this situation. This particular person that's asking you all for a variance in this case has a circuit court case going on right now with neighbors telling them how to use their property.
No, that's irrelevant.
So I do think it's important to point that out. I don't know how much, I'm not suggesting that that's necessarily something that you should necessarily consider, but I do think when at least in court, we have what's called the clean hands theory. If you're going to come to court and ask the court for equity, you have to have clean hands. And so in this situation, Mr. Murphy doesn't have clean hands. He wants to dictate what other people do with their property, but when someone has, but when someone points out that he's also using his property in a manner that's not consistent with what the law is, he comes here and wants you all to give him a variance after he's filed his application, after he's built his barn, and after he's done all these other things that makes no sense and shows that it's not fair. Now, if that's not enough, I ask you to go ahead and turn to the where I have the pictures towards the back of there. The first one is a deer target, which is on Mr. Handelman's property. This is not his deer target. And so I'll have to, we're not sure where that came from, but we have an idea. The second page there is a picnic table, a bird bath, and some other things. Those are things that the applicant uses for his barn, except they're on Mr. Handelman's property. He's decided that he can use Mr. Handelman's property to put his things. Then if you turn to the next page, again, it's just a close-up of where he chooses to put his things on Mr. Handelman's property. And then if you turn to the next page, there's the page where you see the wood pile. This is the survey pen. the little pink ribbon there, that's the survey pin. That's how close the barn is to Mr. Handelman's property. Literally right next to it. And then I think you should turn the page to the gravel there. That pin, you can see the pink ribbon on the pin there? That's actually Mr. Handelman's property. But what the applicant has done is decided to put his road on my client's property. And ironically has forbade him to use it. If you turn 2 more pages, you'll see a lot of stuff over here up next to these trees. That's also Mr. Handelman's property, but that's not Mr. Handelman's stuff. That's Mr. Murphy's stuff. And then if you turn the next page, you'll see again additional things that are on Mr. Handelman's property, but they're not Mr. Handelman's stuff. They're the applicant's stuff. And so the concern here is that the applicant is coming to you all saying, I need a variance because I screwed up. I decided at some point just to put my barn wherever I wanted it. I had all this property that I could have put my barn on and didn't bother to make sure that I get the barn in the right spot. But now that I've violated the zoning ordinances, I want to come to you and get your blessing to make sure that I can just keep it where it's at. Another thing I would show you, Alan, the applicant also likes to play golf. And these are the golf balls that goes from where he plays golf onto Mr. Handelman's property. So he also likes to play golf. And this is what Mr. Handelman does, is goes and picks up the golf balls. Because he doesn't necessarily want Mr. Murphy's golf balls on his property. He didn't give him permission to do that. He just decides that I can use the property any way that I want to. I can just go ahead and put my building anywhere I want to. And now I can come to you and ask you for a variance, even though I want to go tell my neighbors what they can do with their property. And so we would ask you all to follow the recommendation. I am, you know, part of this is to let you all know a little bit about what's kind of inside here and going on. But I do think as a person who sit in a situation where you have to kind of make these types of decisions, you know, you do have to think about precedent. And I think you have to think about what kind of precedent are we going to set if we decide that anybody can build their house or their outbuilding or a barn anywhere they want to, and then after I told the planning and zoning, or excuse me, after I told the building inspector's office that I'm going to build it 50 feet off where it's supposed to be, I don't go get you know, he's already indicated to you all he doesn't know how to go get a surveyor. That's what you do before you build a building like this, but he chose not to. And so we would ask you all to go ahead and deny the request in conformity with what the staff has indicated you all in this case. And I appreciate your all's time. Thank you all.
So for my clarification,
Sure.
I want to get this in my head to make the fair decision, okay? You purchased the property in what year?
16, it says. The record says 16.
You got farmstead at 2018? When did you build the barn?
That's when you signed it.
And when did you build the house? And Mr. Handelman, how many years have you owned the property? So you two have been neighbors this long? And we're waiting till April or March of 2021 to complain that the barn's there and he's using his property? I'm having a hard time following what generated this. The barn's established. I drove down there. There is no way in crap that you could find that place if you didn't know it was there. I mean, I understand that you have property and that you don't want the encroachment. I'm just trying to understand why all of a sudden this is an issue. And I agree, if he violated the rules, he violated the rules, but.
I guess the new survey is what prompted it.
But is it surveyed by who?
I'm sorry now?
Did you all pay to have the survey?
I had a survey done.
He paid to have it surveyed because,
I had a survey done, and the survey is, the date it was signed is 12/28/20, so this was last December.
Okay.
to answer, if I could answer, if I could just state this real quick, there is an easement that Mr. Handelman had been using for the entirety that he owned the property.
To go down that gravel road?
To go down that gravel road, to go to his property, he owns, I didn't.
90-some acres.
He owns property on both sides.
Right.
And so he has a tractor that he wants to take from one of his properties to the other without going on 25.
I understand.
Mr. Murphy approaches Mr. Handelman and says, if you give me 2 acres of land, I'll let you keep using the easement. And Mr. Handelman says, I'm not giving you my land. In addition to that, he tells another person, it's in Scott Circuit Court, he tells another person, if you give me 8 acres of your land, then I'll let you develop more of your property. But I'm not going to do it unless you give me 8 acres of your land. Give me 8 acres of your land. And so he's cut off access to the use of this easement. He has gravel still on my client's property. He's built this place in a place that it can't be built. He wants to keep, his concern is, I don't want to see other rooftops from my house, but yet Mr. Handelman gets to see his rooftop. It's just 24 feet from his line. So I would just indicate that, again, I do think it's very important when you're looking at these types of situations, at these types of cases, that you do look at precedent. And I would suggest to you that whatever's really going on here, it sets a very bad precedent for something like this to be granted when there's no real reason why it should be done this way. There's really no reason. It's not because the zoning laws changed. It's not because things have happened since the time he built the barn, legal-wise, that all of a sudden made his barn illegal. He chose to change what was the status quo between the parties, and he's not. And now he because now he's facing this situation. So I appreciate your all's time.
Thank you.
I'd like to respond to just a few things you mentioned there.
I have a few questions for him too.
I didn't see the pictures you got, but as far as the gravel road, I extended the gravel road so he could use the road up into his property. That's the reason the gravel road it's going on his property, so he could use it at the time. As far as the easement, if you look at that plat earlier I showed you, M338, I've got 4 building spots. I've got 4 building lots here that was pre-approved. The only place I could really build on this lot here is, the reason I didn't necessarily want to give him a platted easement to this property here is because my building spot is right there. And my garage is right there. I had no problem with him coming through my property. I just could not give him an easement on and still build a house in that spot. So, and then the gravel road we extended up here just simply because he wanted me to. He wanted me to bring the gravel up to the top of this little hill right there. So
Well, I don't
there's
think
more
he's,
to that than what he's he's saying one thing, but there's more to it than that. And as far as my little deer thing was, I mean, some of that stuff was, up until a few months ago, I thought was on my property, so.
So that's my question. He's showing us picture of woodpile, of targets, of a picnic
Well,
table, that's all on the other
that's-
side of a survey line, not that one, the other ones. Have you moved this stuff since this has come up in question?
This has been moved, yes, this is all moved over here now. This is not there, this is not there, this is all over next to my garage.
It's all moved over past the survey lines.
Yeah, when I was there today, I didn't see it. We thank you all for the information.
I would just like to add that this survey.
Would you come to the podium, please?
I could not have told you before having the survey, I couldn't have told you exactly where the line is, because the pins are pretty far away. And it's difficult when you're dealing with woods to know that there's a pin over there and there's a pin here, and
I agree.
It's true.
where exactly is that line, so I couldn't have told you. And, you know, I got the idea, well, maybe I'd like to put a fence in here at some point, and I decided to have a survey done. Until that point, I wouldn't have realized exactly where the line was. But, and also, you know, there's, I think this thing about the golf balls just kind of expresses just a wanton disrespect for someone else's property. I mean, I know that's kind of a dramatic way of showing it, but to go out there and constantly find golf balls on your property, I mean, I asked Fish and Wildlife, and they told me the golf balls don't migrate. So, you know, these aren't Canadian golf balls that came south for the winter.
So where do you live in this subdivision?
I have I do not live in the subdivision.
Okay.
I have a large tract of land on either side of Summer Ridge Road.
Mm-hmm.
And my house is on the southern tract, and the northern tract is the tract that borders Mr. Murphy.
So to get to the land, to get the golf balls, how do you get there?
Well, I have an entrance. I have a field at the north end of my property. I drive in there and I walk all the way up the hill. You know, I walk my property a lot. That's something I like to do. That's why I like having property. I like to hike.
I just wanted to know, because when he said the easement, you're not using that easement anymore, that's what I wanted to know, where.
Right.
But he said the easement was just to avoid the tractors on 25. You can drive a car and go to either end, but you were just trying to do a straight cut through with your tractor.
It was
or whatever.
much easier if I can take my tractor. 25 is a very dangerous highway, and I don't
agree
feel
totally.
comfortable going 15 miles an hour on it in a tractor. And, you know, and I have an easement through there, although Mr. Murphy is saying now that I don't. He was okay with me using it at first, and I even offered to share the cost of putting gravel on it. He never asked me for the money, but I offered to help with that. And he didn't have a problem until at some point he felt that that would be good leverage to get 2 acres of land from me at a point when he was trying to negotiate another deal to get some land in exchange for a housing credit. And because of the shifting around of the reserved area, there was a need for another couple of acres. I think it had something to do with reserved area having to be contiguous, a certain minimum contiguous amount. My northern tract is primarily green space for Summer Ridge Road. So my southern tract had housing credits, and it was a better place to build anyway, so I built on the southern tract. But I do need occasionally to move that machine back and forth, and it's the safest way that I have to do it.
All right, thank you.
Let me just comment, part of it's been said about the golf balls, and I understand that. I live on a golf course.
Okay.
And when the players hit the ball, it goes away from my house. It goes in the opposite direction. But I get golf balls over in my yard quite often. Grandkids love to play with them. But I don't take issue with them doing that. I know there's times they're probably feeling pretty happy that they shoot it in the wrong way. But I think golf balls, I just kind of take issue with that. I just don't think doesn't seem to be that much of a problem with you. Do you all have livestock or anything like that?
I do not have livestock.
Do you, Mr. Murphy?
No.
Okay.
They're just
these were several hundred feet.
But
I have 85 golf balls in that bag.
We thank you. Do you have something you?
Yeah, I mean, with all due respect, the golf balls to me, it is what it is.
Yeah.
We've digressed completely away from the main issues.
Yes.
So if you begin to look at what we're talking about here, it's a nuisance, I get that. I hit a golf ball, trust me, it doesn't go where I want it to. I get it, understand. But the fact of the matter is, what we've got to come back to is whether we grant the variance that has been applied for, okay, regardless of evidently a lot of underlying issues that's going on here. That has nothing to do with us.
Right.
Okay, the underlying issues are between the two of you. At the end of the day, I don't mean I don't care about them, but at this point, I really don't care about them. Okay, they're between you guys. What we care about is the variance granted or not? There's a couple issues, and I'm speaking for me personally at this point, okay? The survey that's done, there's a code of ethics that surveyors have to follow, just like judges, just like attorneys, and everybody else. Do I believe the survey is correct? Yeah, I do. Okay? Because they have to come out, they have to do those things, and I'm speaking about the recent survey that was done. Do I believe that the house or the barn has encroached on the property? Yes, I do. The reason I say that is when we came before this in 2018 or 2019, Matt, I don't remember, it was laid out that you would stay 50 feet away. Do I believe you could have had a survey done? Obviously, you built a house as well. So the normal thing to do, and we just had to do this in 2016, is you get a survey done. At the end of the day, you get a survey. And if that's not done and something happens in between, well, that's kind of on you at that point. It happened. So at that point, what we have to figure out is, do we go back and set a precedence? That's the dangerous thing. Do we want to have this conversation every meeting from somebody else when we come back, just because I'm going to ask for forgiveness rather than permission to begin with? And we've got a lot of people in Scott County. So that's where I'm at. It has nothing to do with golf balls or wood piles or a deer stand or anything else. It's simply, is it granted to go back and ask for forgiveness rather than permission?
I agree with you 100%.
I'm not asking for agreement by any means.
No, I
I'm
do.
glad you do, but I'm not asking for that. I don't know either one of you at all. What I'm saying is the matter at hand is the encroachment done properly?
But I would like to expand on that, Darren. As far as the golf balls, or, you know, you were saying it's no big deal. I do see your standpoint that, you know, it is a relevance here. I had a neighbor that kind of encroached on my property because I don't use the back 2 acres. They thought they could. So, I mean, it seems to me like the golf ball's kind of the final nail in the coffin. You have the picnic table, you have the other things as the property's being used. Now we know that is your property.
Right.
And he has moved it. He's moved the stuff off your property, he says, so that's a good. But if you ever do want to put up the fences, like you said, Darren, I don't think that he chose to do that at the time intentionally, but there has been some underlying lack of concern about his neighbor's property. He has used it, he has encroached, and he has been given opportunity to survey in the first place, plus 2 months ago, or whenever we've had the extension. I mean, I've never had a survey. Well, my husband handled it for my house, but if we were going to build another piece of property, because of the fact the neighbors tend to do that, first thing I would do is I would get a survey before I would put money into something. And like you said, we do not want to set where people can just, lackadaisical, do these things and then come and ask for forgiveness. That is a dangerous, with all the building going on in this county, people need to be sure of what they're doing before they do it. That's my opinion.
Now, something else also, you all have heard me say this many times. We have laws, we have regulations for all these kind of applications. And having said that, there is a reason that this board is called the Board of Adjustments for variances and things of that nature. So there are extenuating circumstances at times, and I think this is one of them. Now, having said that, Charlie,
Well, but our staff has not found any extenuating circumstance. That's what I was going by.
I want your
Well,
legal advice.
well, unfortunately, the state statute's pretty clear. I mean, it even starts out, before any variance is granted, you gotta consider these things, and you gotta find these things. Well, Matt went through them. The requested variance arises from special circumstances. Well, no, it doesn't. There are other locations. Strict application would deprive the applicant of reasonable use of the land. Clearly, that's not true. It would not deprive him to put it where it's supposed to be. The circumstances are a result of actions of the applicant taken subsequent to the rules. Well, yes, it was. Now, was it willful or not? Matt wasn't willing to say it was willful. We've got no testimony that says it's willful. But it clearly was taken when the rules said you don't do that. So basically, the state says you go through these things, you've got to find those things are correct, or else you can't give a variance. It says you shall do this. I don't know that I would say you have no authority to give a variance when these things aren't satisfied, but when none of them are satisfied, basically what happens is, sure, you have the authority, and all they've got to do is appeal it, and we lose, because the statute is not satisfied. We've had situations before. Generally, it's, little errors. It's not, well, I didn't get a survey, I thought that's where it was. I don't even know what to make of the picture that shows the survey stake, just, you could flip a coin and hit it. As I said, do you have the authority? I'm not going to say you don't, but I'm going to say this would not stand if you do that, because it doesn't satisfy the statute. These things should be given, number one, ahead of time, but we do give them on occasion when there's a good faith effort, there's a mistake, there's just innocent errors, and there's no damage as a result. Boy, this one just simply doesn't satisfy that. And it does bother me, that's the reason we gave continuances for a couple of months. Get your survey. Because, as you said, that should have been the first thing. It certainly should have been once the question was raised, if you believe that this is indeed wrong, that the line's somewhere else. So, as far as giving extra time, well, that's been done already. The building's been there. And while I totally agree that those other issues really aren't relevant, lawsuits and all that, gosh, on the other hand, they do kind of lend some explanation as to why some of this may have happened or may have not been fixed. I don't know. But none of it, frankly, I think legally compels you to do anything but say no, because the statute's not complied with, and we just can't change the law. We're here to apply the law. And when there are extenuating circumstances, such as number one, well, except there aren't here, or when strict application stops you from having reasonable use of your property, well, we don't have that here. It's pretty clear.
Do we have any other discussion or comments?
Well, Charlie, what has to happen if we agree to deny this? What does Mr. Murphy have to do with that building?
Well, first thing he's got to do is either come into compliance, which means move it back 26 feet, or he's got to file an appeal. And I'm not going to give a legal advice as to what that would be for him, but I will give you the advice that you don't want that legal action going the other way. Because, period, the statute's clear.
No leg tent.
So he either has to file an appeal, which will delay the inevitable, I think, or else he needs to move the building. He needs to put it where it should have been in the first place. And we've done that before. Here we really haven't so much, but we've had violations before where inspections weren't gotten. These are mostly in the city. In fact, as far as I can tell right now, I think they were all in the city. But they didn't measure it, didn't double check it, measured twice, cut once. Well, they measured none and built. Well, things had to be moved. Period. Those are the options he's got, I believe.
Need to come to the,
You have to come to the podium, please. Sorry.
That little spot where my garage is, it does slope down the hill right there. Is there a way to maybe get a variance on like 35 feet from the property line? I can move part of the building and still stay up on that little knob there, or would that be unreasonable?
But that, you said we still don't have any things to justify that either. If you can't do the 26 feet, you can't do the 35 feet, correct?
Yeah, it's possible. It doesn't appear in this situation that it would apply. It is certainly possible to have a situation where the location is not defensible, but in fact, circumstances are such that we probably wouldn't require the full 50. But again, none of that looks to apply here. It looks like there's ample room to do that. And I think even earlier, Mr. Murphy talked about that he thought, and I forget now exactly what it was, but it showed there was an error in the original line, but it's not 26 feet worth. So even if that were true, and I'm assuming it is, I'm not.
I'm sorry, I didn't get that. What?
Well, you had said something about that you were quite sure this was an error from the original lines where you thought they were, but it wasn't a 26-foot error. So
No.
even if all that's true, it still does not give justification for putting it.
It was 26, I mean, the original stake and the flags were, the way that barn is angled, it did throw me 50 feet from the line that was previously marked.
I apologize, that's just not correct. That's just not correct. I mean, that's just not the way it is. I mean, I just felt like I at least need to stand up and say that for my client. That's just not
What?
correct. He didn't do anything to figure out, he didn't know where the stuff was. He just built it.
Again, at the end of the day, what it comes down to, we have a variance request in front of us right now. If we deny that, I'm assuming he could always come back, and as Charlie said, he could appeal the decision, or he can apply for another one if he chooses to after a survey is done. Actually, there's been a survey done. But at this point, what we have to vote on is this. We would be making assumptions on anything else at this point. We don't have anything to go on. All we have is what's in front of us.
And there's no, like Matt said, there's just no circumstance there for us to
Right.
make an approval on, not based by following it's not an adjustment. First, they have to meet one of those requirements before we have an adjustment, and there is no meeting of any of those.
Is this, does the garage gotta come down tomorrow? I mean, I got a letter
no,
saying.
no,
I'm
of course
We
not.
haven't voted.
We hadn't voted yet, though.
Yeah,
I don't know.
If that's the vote, no, of course not. It would be a reasonable amount of time to do it, but it's got, if that's the vote, it would have to be done. It would have to be done in a reasonable time, and that's a time that you all would set. Or that if you didn't set, staff would set.
Which might be just let staff go by their regular guidelines and set that.
Do
I'd
you
hate-
have any, does the office have any kind of a time frame or anything for something like this?
I don't have any personal experience with, buildings being moved or anything like that. Our typical timeline is 30 days, and the applicants are, or I guess people who are in violation are free to request extensions on that. In this case in particular, we send a letter and tell them there's a 30-day period where they either need to apply to the board of adjustments or rectify the situation. Like I said, they're free to apply for extensions to that, and I'm sure Joe would hear those and determine whether or not those were reasonable requests. Progress is being made somehow.
But if such a request were made, there'd be a justification would have to be submitted with that. So if the person that's doing it's gonna need another 20 days, well then fine, I'm sure that
I'm
extension
sure
would
the
be given.
office would work with him on that, because you've got weather and all that to
Yeah,
contend
but you couldn't have
with.
the open-ended, just not now.
I can't imagine that being approvable of anyone.
Yeah, kind of like, yeah.
Do we have any other questions or discussions?
No, one thing I'd like to say before we take the vote, regardless of which way this goes, I would like to see you two, people that's involved in this, at least get up and shake hands, because I can see there's some animosity there, and I hate seeing that, especially in today's world. But I would hope that you all could become good neighbors again and get this behind you and maybe work together on certain issues and work with each other.
I'll accept the motion.
Sitting on these boards, you always want the answer to be an easy one and walk out, but at the end of the day, we have to follow what the law says. So saying that, I make a motion to deny S 2021-13 based upon staff recommendations.
Second.
I have a motion and a second. All those in favor say aye.
Aye.
Scott County Board of Adjustments denies application sure Mr. Murphy, you'll be contacted by Matt in his office. I apologize, I hate to see you have to move the building, but as stated, we have guidelines that we have to follow. Yes, sir. Our next item is S 2021-19.
Thank you.
That will be postponed.
Didn't
Moving to item S 2021-22.
Oh, I did figure it out. See,
Thank you. This application is for a conditional use permit for a home occupation, for a federal firearms license. Home occupation is what our ordinance calls home businesses. The location of this application is 101 Willowbrook Lane. The property is also zoned agricultural, as are all of the surrounding properties. The site is a 1.3 acre lot with access from Willowbrook Lane. There are no previous conditional use permit or variance applications on this lot. Based on, my reading of, the materials submitted by the applicant, I find that it would have minimal, if any, impact on neighboring property owners. There shouldn't be any, noises, odors, light flashes, glares, things like that the ordinance describes. The applicant has plenty of driveway space for any one-on-one visits with clients. So I recommend approval based on the findings that are there in the staff report and with the 4 conditions that are listed in the staff report.
Thank you. Is the applicant present? Want to come to the podium? Explain anything he hasn't told us?
I'm sorry?
Explain anything he hasn't told us?
It's pretty much it. I just, something I do on the side. It's kind of a hobby, and I was looking at doing something more business-like, retirement hobby. That's all it is.
Okay.
Mostly just friends and family now, and maybe more later on.
All right. You haven't heard any issues with neighbors that you contacted?
Any complaints or curious calls from neighbors.
Okay. Do we have questions, discussions? I'll accept the motion.
I got my wrong number. I'll make the motion, but my numbers are messed up.
22.
I'm sorry. Yeah, okay. I'll make a motion that we approve application S 2021-22 for a federal firearm application at 101 Willowbrook Lane.
I'll second.
I have a first and a second. All those in favor say aye. S 2021-22 is approved.
Now, he's wishing he went first.
Sorry that you had to sit here for it.
That's my first rodeo.
Well, our rodeos keep getting interesting.
Woo-hoo, yeah.
We're going on to S 2021-23. Matt, your findings?
This application is a conditional use permit request as well. The applicant is looking for a secondary single-family residence at 375 Burgess Smith Road. Once again, the property is zoned agricultural, as are all the surrounding properties. This site is a 10-acre lot. The applicant also owns the surrounding larger farm as well, but the 10 acres on this lot is large enough for 2 homes. So based on the findings that, the project site has the sufficient size to meet our density requirements. The applicant stated in their application materials that it was for a family member, which is required by our ordinance. I recommend approval of this application with the 4 conditions listed in the staff report.
Thank you. As the applicant, would you like to speak to us, since you're the only man standing?
Yeah, we actually own 121 acres, but it's one deed with 2 parcels, and it just happens to fall on 10 acres. It's for my wife's parents, my in-laws. They're 70-some years old, retired. And we own a place in Berea, we did, and they lived on that land, so we're obviously gonna bring them up here with us. That's pretty much it.
We can deny this if you want.
Yeah.
At least move them off to the other side of the 100 acres, right?
They always find out.
All right.
There's no sense in doing that.
You're right.
You are not gonna pull one over on the wife.
Just thought I would offer.
Not gonna happen.
I might have to talk to one, don't
So will you be building there or moving?
They have a double wide trailer the site. We've already had it perk tested and all that, so I'm guessing all of those, forms need to be sent to you if it's approved.
I don't need those, but you'll send them to the building inspector.
Yeah, you need to get real friendly with the building inspector.
Yeah, well, I was just wondering, cause in here it said all licenses and stuff come.
Yeah, you can send them to me.
I was just wondering, that's all.
To be honest, I put that on a lot of conditional use permit.
I'll just email you and ask you what you want.
It's better to ask for permission.
Yeah, we just found that out, didn't we?
That's why I'm asking.
We all, any questions of him? Thank you. All accept a motion?
Go for it, Rachel, go for it, Rachel. Good.
I move that we accept the S 2021-23 conditional use permit for a single-family residence at 375 Burgess Smith Road.
Subject to the staff report?
Subject to the staff.
Thank you, ma'am.
Second, Darren is second. All those in favor say aye.
Aye.
S 2021-23 is approved. Thank you.
Motion to adjourn.
The meeting, if there
Sorry,
are
you had
no
to wait
other
too.
issues, we will adjourn the meeting. Now, remember the